Morning, Your Honors. The matter before the court this morning is the case entitled State of Vermont versus Nikolai Beldiman. Case number 25 AP 269. Representing the appellant, the State of Vermont, is attorney Michelle Donnelly. Representing the appellee, Nikolai Beldiman, is Avi Springer.
Thanks very much, and good morning, counsel. We'll hear from counsel for the state. The appellant first, of course. Please, for the record, introduce yourself and identify your client, and then proceed.
Certainly. Good morning, and may it please the court. My name is Michelle Donnelly. I am the state's attorney of Washington County, and I am representing the appellant, the state of Vermont, this morning.
Thank you.
The appellant is here today to ask the court to reverse the single justice entry order, which declared 13 VSA 1063C unconstitutional and found that aggravated stalking was not a crime of violence for the purposes of determining bail.
Counsel, you're asking that the hold without bail order be reinstated?
So I'm asking, I suppose that now that the defendant has been released for 30 or so, for 2 weeks-ish right now, the barrier that the state would face at this point to holding the defendant without bail would be whether there's clear and convincing evidence that he posed a risk of physical violence to another person at this point, and whether there are conditions or combinations of conditions that could adequately protect the public. But what I'm really focusing my argument on is the entry order that declared the 1063C, which says that aggravated stalking is a crime of violence for the purposes of determining bail unconstitutional, and that aggravated stalking is not a crime of violence on its elements.
Ms. Donnelly,
What would the mandate read? What are you asking the mandate to read?
I'm sorry, Justices, I did not hear the questions. Two of you were talking at the same time.
I'm sorry, I said, what are you asking for as a mandate here?
I'm asking that the court uphold the statute of 1063C as constitutional, and that aggravated stalking is a crime of violence. I suppose I'm asking for you to reinstitute the hold without bail, at which point I'm positive that Attorney Springer would probably file a bail review asking for conditions of release to be put in place.
Right, because you're going to run up against the 60-day deadline, correct?
We would also come up against a 60-day deadline, although the 14 days that he's been out would not count against that. Yes.
All right.
Donnelly, I'm trying to understand if this is an advisory decision or not as to the determination of whether or not the aggravated stalking is a crime of violence.
I do think that that is the piece that is most important for this court to determine, is that right now there's a single justice entry order that is declaring a statute that has been in place for 32 years unconstitutional, and that we need an answer to that question. And
well, what about Ms. Donnelly? I mean, I'll interrupt you through your in the middle of your sentence, but the limited right of the state to appeal a single justice decision, it's very specific as to when and when it cannot be and what the circumstances are for the appeal.
Yes, and I think that even with those limited circumstances, this is one of those limited circumstances. This entry order was issued under 7556D, where it is silent about a right to appeal. Under 7556B and C, the statute is clear that there is no right for further appeal of those single justices entry orders, but there is not such language in 7556 D, and this entry order did release the defendant, and under 7556C, when a defendant is released, the state has a right to appeal.
True, but isn't the right limited to a single justice?
And then that single justice can refer it to the full panel, which I think was which occurred here.
I read that statute as an or. It can either issue a decision or refer it.
Right, and I think that it was referred.
But counsel, isn't your point here that once the single justice strikes the hold without bail order and imposes conditions of release, that triggers your right of appeal under 7556C?
Yes.
Is that your position?
Yes.
Thank you.
So the state is asking for this court to hold that 1063C is constitutional. The appellee's argument focuses on language saying that the legislature has no right to add to, alter, abolish, or infringe onto the Constitution, and 1063 has not done that. 1063C predated this constitutional amendment. 1063C came into being during the 1993 legislative session. It was signed into law in June of 1993, and the Vermont voters voted in November of 1994, a year and a half later, after this 1063C had been in place for a year and a half. So when the voters voted to amend the Vermont Constitution and create this hold without bail exception for felony crimes of violence, they already knew what crimes of violence they would be considering, including 1063 aggravated stalking, first-degree aggravated domestic assault, and second-degree aggravated domestic assault were specifically designated prior to the amendment of the Constitution.
Do you agree that Section 40 sets the parameters of what is and is not acceptable?
Yes.
All right. And with that in mind, we have 1063C. And so my question to you is, what is the limit, in your view, of the state's power to designate crimes as being ones of violence for purposes of bail, if those guidelines are not set forth in Section 40?
So the Chapter 40 of the Vermont Constitution talks about felony crimes of violence. Aggravated stalking is a felony crime of violence. The legislature, by putting in 1063C, was giving the criminal justice system and trial courts direction on how to see those cases. I really do think that the legislative history there is important, that in 1992, the Vermont Judiciary commissioned a study that uncovered systemic violence in the systemic bias in the criminal justice system, specifically regarding crimes against women, and that the 1993 Act 95 Act was passed to address that systemic bias of these crimes of violence against women, creating the statute of aggravated stalking, aggravated first-degree domestic assault, and second-degree domestic assault. And so that was already there. And I don't think that this is that different than there's a constitutional right to bear arms in the Vermont Constitution, but the Vermont legislature has made statutes defining when some regulations and confining some of that right to bear arms in certain ways by defining when that can be infringed on. And this court has upheld those statutes. Like, I would point the court to State v. Mish at 214 Vermont 309, where the legislature said that you couldn't own large capacity magazines. And the defendant in that case argued that that was an infringement on the Constitution, made the same argument that the Constitution language could not be added to, altered,
You have
abolished,
one,
infringed
you have
upon.
1 minute, counsel. You have 1 minute.
Thank you. And this court said that that was a proper exercise of legislative authority, and I think that this situation is very similar.
Good counsel, could the legislature take note of the carnage caused by drunken driving and say add something in 23 VSA 1210, for example, that repeat DWIs are crimes of violence for purposes of bail consideration?
Well, I think that you still are going to have to have crime of violence determined, and then the additional safeguards against those accused of crimes or their liberty interests are in 7553A and the bail amendment, which says that the state has the obligation to prove by clear and convincing evidence that the person poses a risk of physical violence towards another person, and that there are no conditions or combinations of conditions. And so I think that those are the safeguards that would prevent someone accused of, say, a DUI number 5 from being held without bail.
Does it matter if there was an accident and injuries?
I know I have no time remaining. Would you like me to answer that question?
Chief, is it okay for
Oh,
just a
yeah,
quick
please,
response?
please,
Thank you.
yeah.
I think that even if there were injuries or potentially even a death in a DUI number 5, that would probably wouldn't qualify for that risk of physical violence towards another person, because I don't think that a DUI would be classified as violence, because it doesn't have that abusive or unjust use of power, which has been the definition of violence that the Vermont Supreme Court has been using for years.
Okay, your time has expired. Thank you. We'll turn to counsel for the appellee, please. For the record, introduce yourself and your client and then proceed.
Good morning, Your Honors. My name is Avi Springer. I represent Nikolai Beldiman in this case.
Thank you.
I'd like to start with the issue of whether the state has a right to appeal in this case, and I take the position that it does not. As the court knows, the state has no common law right to appeal and only has a right to appeal in criminal cases where it is granted one by statute. The statute that the state relies on here, 13 VSA 7556C, provides the state with a right to appeal when a person is released with or without bail or other conditions of release. I think the only practicable reading of the statute is that refers to the state's right to appeal the decision of the Superior Court to either a single justice or a 5 justice, or to the full court if it's referred, and does not grant a right to appeal a decision by a single justice who has already conducted the first level of appellate review and reversed the Superior Court's decision. I see that.
Isn't the hearing under 7556D a de novo hearing? And wouldn't your position lead to a one justice unreviewable de novo hearing?
Yes, and I think that that's the way it has to be, because 7556C goes on to say that there is no right to further appeal of the one justice decision by the state. So there are plenty of instances in which the defendant has a different right to appeal than the state does. That's present in the statute. So I think it would lead to an untenable result if the state were allowed to appeal the one justice decision, reversing the trial court, because if only a single justice then heard that appeal and decided something to the contrary of the first single justice, you'd have two conflicting single justice decisions with no possibility to have that reviewed by the full court, which I don't think is a result that the legislature would have intended. I think also
No, I'm trying to figure out between 7556C and D, which one applies. Because technically he was held without bail, and then that was what was appealed to the single justice determination, the justice who was appointed.
So I want to make
And
sure
then-
I understand Your Honor's question. So I think 7556D and 7556E, neither of those create any right for the state to appeal. So the only section that the state can rely on is 7556C. I think that's really important because the legislature in 7556D and E, they clearly know how to write a statute that gives specific rights to appeal. And they didn't do that in 7556C. Arguably, there's a little bit of ambiguity in 7556C because it doesn't say whether the right to appeal is from only the Superior Court's decision or from a one justice decision reversing the Superior Court. But again, I think for the reasons I've explained, it's an untenable result to have review of the single justice decision by another single justice, and then review stops there without any possibility of resolving a split. I think we're also in Title 13, the criminal statute. So to the extent there's ambiguity, I think that must be construed in favor of the criminal defendant under the rule of lenity.
So is there any way that 7556D is the applicable statute, or is that only for the defendant or the defendant to use?
I believe by its own terms, it's only by the defendant.
Could you tell us what those terms are?
I'm sorry, I didn't.
I said, would you tell us what those terms are in case we have a somewhat different reading?
So sorry, the terms of what?
You said by its own terms.
Oh, sure. Sorry. So subsection D says a person held without bail is entitled to, and then it goes on to describe the process. So the statute's language is restricted to the rights of the person held without bail to appeal. Nowhere in that section does it talk about the state's right to appeal.
But if I recall correctly, that section does not say, as it does elsewhere, no further appeals shall allow.
That's right, it doesn't. And that sort of, if a person loses the person held without bail loses the one justice review he's entitled to or she's entitled to under D, then they go on to E, where you can have review by a panel of three justices.
But if we have a hearing under section D, and the judge imposes a bunch of wacky conditions for one reason or another, there's no review of that, according to you.
Not under E.
No, under D.
Right.
Hearing under D, the judge says, okay, I'm imposing conditions here, striking the hold without a bunch of, or maybe you don't even get to that, but imposes a bunch of wacky conditions. You're saying that the state can't come in now under 7556C and have those conditions reviewed. They're stuck with them.
Yes, that's my position.
Okay.
With regard to the merits of the issue, I believe that the legislature exceeded its authority in enacting 1063C, in infringing on the right to bail set forth in Section 40 by essentially redefining what crime with an element of violence means. And as the court knows, under Vermont Constitution, Chapter 2, Section 6, the legislature shall have no power to add to, alter, abolish, or infringe any part of the Constitution. That's a principle that's echoed in case law. In State versus Lambert, for example, the court said that the Vermont Constitution is not a grant of power to the legislature, but a limitation on its general powers. In other words, the legislature does not have the power to redefine the plain meaning of terms as they're used in a constitutional amendment to infringe upon a person's individual liberty right under that amendment.
I know we're considering the constitutionality of 1063C, but let me ask a slightly different question. Why is 1063C necessary, or what does it add to the analysis if Constitution sets the guideline?
I don't think it adds anything, and I think it's a nullity because it exceeds the power that the legislature has. Because as I explained elsewhere, I think if the court proceeds to the analysis, it would, absent 1063C, the crime of aggravated stalking using the analysis prescribed by the court under Filippo, looking just at the elements, does not qualify as a crime with an element, including an act of violence against another person.
And can you expand on that point? Why it doesn't qualify?
Sure. So I think what we can do is look to the various cases in which the court has construed what violent crime means for purposes of 7553A and the constitutional amendment. And first, we have Combs, in which the court found that manslaughter qualified as a violent felony, notwithstanding the absence of a specific intent element. In that case, the court focused on a dictionary definition of violence as, quote, physical force so as to injure, an instance of violent treatment, and destructive action or force. I think under those really plain meaning interpretation of what most people would think violence means, aggravated stalking's elements clearly do not constitute a crime of violence. The court began to expand or apply more expansive definitions of violence.
You have 1 minute, counsel. 1 minute.
Sure. So the court began to expand the sort of definition of violence in future cases like Madison and Perrin. I would argue that I think that the court in those single justice decisions began applying a definition of violence that really strayed beyond the common understanding of what violence is. But I think even under the expanded definition of violence used in those cases as something requiring abusive or unjust use of power combined with the creation of fear of imminent serious bodily injury, aggravated stalking does not require proof of those things as essential elements. So for those reasons and the ones stated in the brief, I'd ask the court as an initial matter to dismiss the appeal because the state has no right to appeal, or otherwise to affirm Judge Thibault's decision.
Okay. Thank you very much. Your time has expired. Please call a conclusion.